So let's go through these then. I want to first cover, I think, I don't know which one is the biggest. You could all argue that these are all pretty big, especially with Chevron doctrine and then the January 6th. But let's start at January 6th. So Fischer versus United States. Tell us what the case, I mean, I could sit here and explain it, but I think you'll do a better job of explaining what the case was even that the Supreme Court was ruling on regarding January 6th.
Yeah, so there is a specific subsection of a statute that has been the legal basis for the federal prosecution of a lot of J6ers and perhaps of even more interest to the viewers. It's also the basis for 2 of the 4 counts in Jack Smith's indictment against Donald Trump in Washington, D.C. So this goes back to a 2002 law called Sarbanes-Oxley, and the context here is important. Congress passed the Sarbanes-Oxley Act in the aftermath of the Enron accounting scandal. Now, there's an old legal principle that Sir William Blackstone mentioned a lot back in the 18th century called ratio legis, which in Latin means reason of the law. What that means in not Latin but English means we actually care about, what is like the context here. I mean, why is Congress putting these words here? You don't do statutory interpretation, Sarah, by just narrowly looking at the words. You have to look at it in the part of the statute that Congress is doing. And what the prosecutors did here is they totally ignored this. They tried to take this otherwise kind of catch-all phrase buried deep in the statute and then say that the J6ers were busting up a congressional proceeding. But Congress passed this law, which again was in the aftermath of a corporate fraud scandal when it comes to gathering evidence and documents in a corporate fraud setting. So long story short, the court today had a very sound ruling when it comes to statutory interpretation 101 first principles. They said that this is an incorrect reading of the statute. And the practical effect is that a lot of the J6ers should have their sentences heavily reduced, if not thrown out altogether. Not all of them, but those who had the statute applied to them. And unless I'm misunderstanding something, I think 2 of the 4 counts against Donald Trump in the Washington, D.C. indictment are now in very, very serious jeopardy. Those will likely get tossed out as well. Yeah.
And this one was I read the obstruction of an official proceeding was the statute that you're referring to. And so I think there's like over at least 300 people who were charged with this. Now, explain, because the Supreme Court said this needs to go back to the lower court and the lower court needs to reconsider the matter. But that's a D.C. court still, isn't it?
It is, but they're going to have to apply this standard still. And the court was pretty clear, the 4 dissenting justices notwithstanding. They were pretty clear that this is just not an appropriate exercise of statutory interpretation. So I'm relatively confident that this is going to play out pretty well from here. I mean,
I'm not like super confident always in the way that the Supreme Court rules, especially when I just want to point out Amy Coney Barrett did dissent with Sotomayor and Kagan. Did you read that? What could you glean from why she dissented with them?
Yeah, I've only had a chance to skim it, but she basically accuses the majority, from what I can tell, of just reading their ideology and preferred outcome into the statute, which is one, really bizarre, because back at oral argument, if I recall, Amy Coney Barrett herself expressed some doubt as to the validity of this particular view of the statute's reading. More generally, I mean, you're a fairly junior member of the court. You probably should operate with a presumption that your colleagues are engaging in good faith here. But, more generally, Sarah, this is kind of the third rail. A lot of conservatives get upset when I say this. But Amy Coney Barrett and Brett Kavanaugh have both been very disappointing. Mm-hmm. They have not been solid picks. Even Neil Gorsuch, who's by far the best of Trump's 3 picks, has been generally good, but he misses sometimes. So Clarence Thomas and Samuel Alito are really the only 2 consistent case-in, case-out conservative originalist judges on the court there. Amy Coney Barrett in particular is rapidly shaping up to be perhaps Trump's single biggest disappointment, frankly, on that court.
Yeah, I would agree. I would agree with that. And then also I'd like to point out before we move on, I would like to also point out that Ketanji Brown Jackson wrote her own concurring opinion, but was one of the 6 in the 6-3. So that was a little bit surprising as well, because usually you see them always stick together, the liberals on the court. Your thoughts?
Yeah, it's peculiar, but like I said, I mean, this is a straight up case of statutory interpretation. I mean, we're talking here about rules of construction that first year law students learn in your statutory interpretation class. It's not it's sexy insofar as it pertains to J6 and Jack Smith and Donald Trump. So it has big ramifications, but the actual legal dispute, is not a massive, separation of powers or federalism or Second Amendment, First Amendment. It's an actual arcane dispute over the specific meaning of the word otherwise buried deep in this Enron accounting era statute. So it's actually a fairly arcane legal debate. It just has massive ramifications. So, good for Ketanji Brown Jackson for being willing and able, I guess, to separate her clear ideological preferences from the actual exercise of statutory interpretation.
Yeah, you don't see that often with that side. Okay, so I want to move on to the next one here. So this is Chevron versus Natural Resources Defense Counsel. And the Supreme Court, I'll just kind of give an overview, and then I want you to fill in the details here if you would. So they ruled in favor of, these were fishermen challenging the National Oceanic and Atmospheric Administration rule that was requiring them to pay $700 daily for an at-sea monitor. And this was like a landmark decision that they overruled from 1984 that became known as the Chevron doctrine. Tell us about it.
Yeah, it's kind of funny, Sarah, but I guess from here until the end of time, or for the foreseeable future, we will all thank herring fishermen for doing away with one of the worst administrative state decisions in the modern history of the Supreme Court. It's kind of funny how these obscure cases sometimes make monumental case law. Ever since I started law school back in 2013, Chevron deference has been a long-standing white whale of conservative and libertarian lawyers alike. So basically what happened was, back in 1984, the Federal Society, which is kind of the conservative legal movement to Oregon — I've been a card-carrying member myself since I started law school — they kind of came of age in the 1980s when judicial restraint was very much on the rise. The problem is that sometimes when you go all in for judicial restraint, Sarah, it has the perverse effect of actually engorging or emboldening a different actor. And Chevron deference had the effect of emboldening the administrative state. It basically said that when Congress passes a statute that the courts deem is ambiguous, then they can't rule on the law. They just have to defer to the agency, the administrative agency, as long as their own interpretation is reasonable or permissible. But that's not how separation of powers works. It was Chief Justice John Marshall in Marbury versus Madison from 1803, the case that gave us judicial review. Marshall, in that opinion, said, quote, "It is emphatically the province of the judiciary to say what the law is, not the province of the deep state, not the province of the apparatchiks in the bureaucracy. It is the province of the judiciary." That is what Article 3 of the Constitution is there for. So it's a great ruling. It's a vindication for the separation of powers, and it's a good day to frankly just ultimately begin this long, slow process of unwinding the administrative state more generally.
Yeah, I also found it interesting, the dissent, which I believe was written by Kagan, but Kagan, who, by the way, it was the three liberals who dissented on this, so the 6-3 split, as you would expect. But I thought it was interesting that she said that agencies, as experts, are better suited to interpret regulatory statutes than courts. And I'm like, have we learned nothing from COVID?
Right.
Are we still relying on the expertise of these people who clearly know nothing? Is that really what you're going with, Kagan? So I found that a little bit interesting as well. Okay, so let me get to this last one here. This is City of Grants Pass, Oregon versus Johnson. And this one had to do with homeless encampments, because I guess the lower court had argued that it was cruel and unusual punishment to actually tell homeless people you can't sleep in the street and you guys have to move. And the court ruled that cities in California and the West Coast, because I think there were a couple different cities that kind of joined in on this. You can correct me if I'm wrong there, but they ruled that these cities can actually enforce laws restricting homeless encampments on sidewalks. And I would say hardest hit Gavin Newsom.
Yeah, I mean, first of all, real quick on the expertise point, if I can.
Please.
So what they're saying on the expertise there, as part of the dissent in the Chevron case, this has been progressivism 101, Sarah, for over 100 years. I mean, going back to Woodrow Wilson and the founding of the modern administrative state, it was entirely predicated on the idea that the experts know better than we the people. Obviously, as you said, COVID and approximately 1,000 other things, the Hunter Biden laptop. I mean, we now know beyond a shadow of a doubt that that is not true. But anyway, on this Eighth Amendment homeless case here, the only surprise here is that this case was not 9-0. I mean, this is a slam dunk if there was ever a slam dunk. You have to be insane. I'm sorry, but you have to be an intellectually dishonest clown in order to possibly say that a municipality, a city or a town's general ban on public encampments is somehow an Eighth Amendment cruel and unusual punishments clause violation. I mean, it's clown car stuff, Sarah. So, Ketanji Brown Jackson deserves some credit, certainly, for going the right way on Fischer. But yet again, when we see a higher profile or a sexy constitutional case, the liberals all line up like the ducks in a row. Good thing the court got it right, though.
So I'm glad that you mentioned how insane it would be to not recognize that that's not cruel and unusual punishment. I want to read a quote here from the dissent, which was written by Sotomayor. She says, "Sleep is a biological necessity, not a crime. For some people, sleeping outside is their only option. For people with no access to shelter, that punishes them being homeless. That is unconscionable and unconstitutional. Punishing people for their status is cruel and unusual under the 8th Amendment." Now, if you wanted to just kind of play that out, extend that logic there, I guess maybe that logic would apply to people who would like to sleep in other people's homes, because sleep is a biological necessity, after all, not a crime. And so for some people, sleeping in other people's homes is their only option. I mean, how ridiculous do we want to extend this to?
Yeah, I mean, Sarah, look, I mean, I could think of other biological necessities that all human beings do every day. I mean, do you want to play that game? I mean, is Sotomayor's argument that the 8th Amendment requires that a porta potty be on literally every street corner and that taxpayers fund it because homeless people they have no place to go urinate or whatever? I mean, it's just utterly ludicrous. Look, the 8th Amendment specifically has been one of the most frequently misinterpreted parts of the entire Bill of Rights for a very, very long time now. Liberals just read whatever they want into that particular provision. I'm not entirely sure why they do it, but yet again, here they are.
Yeah, while I have you here, Josh, I want your expertise, because you are one expert that I do trust. So obviously the debate, I mean, I'm going to talk about it later. I'm sure you watched it. It was just, I had very low expectations for Joe Biden. I frequently do. And somehow it even surprised me. But this morning, this will show you how bad it was. This morning, Chip Roy actually tweeted out, "I intend to put forth a resolution calling upon the vice president to immediately use her powers under Section 4 of the 25th Amendment to convene and mobilize the principal officers of the cabinet to declare the president unable to successfully discharge the duties and powers of his office." What are your thoughts on that? And do you think that it would, because I know that there's a process that has to play out in order for this to even happen. Do you think that it's even reasonable to expect that it will?
Yeah, I mean, full disclosure, I've known Chip Roy since well before he was Congressman Chip Roy. We go way back. I love the guy. I think he's one of the absolute best in all of Congress here. And as usual, his head is in the right place. I mean, this is what should happen.
Yes.
I mean, literally speaking, the 25th Amendment was put into the Constitution for situations just like this. Yeah. So he's right as a constitutional matter. He's right as far as kind of a check on the presidency. But it's not going to happen. Yeah. I mean, it's just not going to happen. I mean, there's no way that Kamala Harris is going to convene, Lloyd Austin and the cabinet. It's just not going to happen. So good for Chip to get this talking point out there. It's a good reminder, a good lesson in civics, if nothing else. Right. But Kamala Harris is not going to do anything with it.
And I think, and I love Chip as well. I don't go back as far as you do with him, but I mean, I consider him a friend. And so I don't mean any disrespect towards this, but I have to wonder if that was part of his, because look, politically, you don't want them invoking the 25th Amendment. Like, you want Joe Biden running up until we go to vote, right? Like, you don't want them to pull Joe Biden. This is an absolute gift to Donald Trump. But to your point about the Constitution, I mean, and also the country, what's best for the country for the next 7 months is obviously not Joe Biden, pretending to run things. And so, but to Chip's point, I'm like, okay, so the vice president would have to convene with the cabinet would have to agree. Then the president would have to say, okay, you're right. And then you're expecting that he doesn't fight it. And all of these things lining up, I'm like, there's no way that you would convince the cabinet, because the cabinet is happy running the show, right? Like, they're happy that Joe Biden is gone. They've known he has been gone for a very long time, and they seemingly enjoy having the power that they do. So you're not convincing, like, even if you wanted to say Kamala would meet with them, there's no way, in my opinion, that she would even be able to convince them, which I wonder that Chip knows and says, you know what, I'm just going to suggest that they do the right thing, because at the end of the day, people are going to be able to look back and say, we suggested that you guys do the right thing and you refused.
Yeah, I mean, Chip Roy is a deeply principled person. You know, he's not there to carry anyone's water other than the water for the U.S. Constitution. I mean, that's just his mentality. And
if he wasn't, sorry to cut you off for just a second. If he wasn't, he would not have suggested this. Anyone who's just playing politics would never suggest that we remove Joe Biden right now. They would wait.
Totally. But, you know, the one thing I will say is, you know, I wrote a column 2 years ago in July 2022 titled "Resign Joe," and my argument was basically that, you know, I mean, politically speaking, it definitely is best for Republicans at this point to go up against Joe Biden. Kamala Harris is terrible, but I guess she'd be slightly politically better for Democrats. I mean, she really is quite terrible, though. But I mean, the point is, I mean, from an American patriot perspective, Sarah, I mean, this is just not acceptable. I mean, Xi Jinping was definitely on the phone with the boys last night in Beijing talking about planning that invasion of Taiwan. You know that Putin's going to go further into Ukraine. Who knows what Iran, Hamas, Hezbollah. I mean, it's just not good. The cartels, I mean, it's just a terrible situation all around. Yeah,
I saw, I know we got to go to break in a second, but I saw someone who posted on the platform formerly known as Twitter something to the effect of like, anyone who doesn't live in our country who is watching this, please just turn off the TV. This is a private family matter, and we don't want other countries watching this. And I was like, wow, that's so true. Josh, thank you so much. I always appreciate the time. I know that you're very busy, but I appreciate you so much.
Always a pleasure, my friend.
All right. Thank you. See you soon. If you like this clip and you want to see the full episode, click here. And if you want to subscribe to the channel, come on, you know you do. Click here.